Been drawn to a ruling of the Supreme Court on the matter as to whether a person presiding as Speaker, consistent with Article 102 of the 1992 Constitution, which provides for the quorum, and Article 104, can exercise a vote whilst presiding. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom, levy for a struggling economy in distress and judicial support for the restoration of a matter that they have said is constitutional is repugnant to the provisions of Article 102 and 104. But what can we do? They are clothed with the mandate and authority to interpret the law. This is a travesty. This is a travesty of parliamentary justice and a stab in the growth and development of multi-party constitutional democracy built on the spirit and principle of checks and balances. Is it not intriguing for us to hear, whilst we await the full reasoning of the Supreme Court, to hear them that, I'm quoting from one of the justices, that the quorum in Article 102 is not the same thing as the quorum in Article 104. For your purposes, can you imagine what will happen in Parliament whilst the first deputy is presiding? There is no second deputy speaker available who will preside to supervise him voting for our purposes. Repugnant and unreasonable decision. He is presiding. So when he is presiding and the second deputy speaker for some purposes is not immediately available in the chamber, he will walk down, vote. At that time, there will be no person presiding over the Parliament of Ghana. This is a judicial support for President Nana Addo Dankwa's e-levy that he is laboring to pass. We remain opposed to it, stitch by stitch, clause by clause, article by article. When it is presented, we will fight back strongly with our 187 amendment.